Hello, I'm Sean Scott. I'm a local elder law attorney here in Pinellas County, and I'd like to talk to you about some issues related to the aging process and the law. Specifically today, I'd like to discuss that dreaded issue of dying. They say in life there's only two things that are certain, death and taxes. When you die, you have some issues that you need to deal with, and specifically is where does your stuff go? How does it get there? And who's in charge of making sure that it gets there? We call this estate planning. Now, we like to talk about it, but it's an important issue to you have something in place for your family to make that process as smooth as possible and, to be honest, as cost effective as possible. Whenever I discuss estate planning with my clients, I use a metaphor of a ladder. So if you can imagine a ladder leaning up against a wall, there's various rungs on that ladder. Each one of those rungs represents a different way of planning for your estate. One of the challenges in dealing with estate planning is that there's multiple ways to get to your solution. Determining which is the right way is the difficult question. Now we start out with that ladder. Imagine it's sitting on the ground. There is that ground level. That ground level is what we call doing nothing. To be quite straight with you guys, doing nothing is an option. You don't have to do anything. Your estate will get to your heirs without you doing anything. There is something in the law called the law of intestacy that says that if you die, or when you die, that your assets will descend to your heirs according to a certain scheme or hierarchy. And it's something that we would normally think like our wife or our kids, it'll descend to them without the necessity of using a will. I don't oftentimes recommend doing nothing, but if you have a very simple estate with not very many assets and not very many heirs, doing nothing may be an okay strategy. However, if you're like most people, you are a little bit more complicated in your world. Moving up that ladder, the next rung is what we call joint ownership. Owning your assets jointly with somebody else is a way of having an estate plan. Most of us do this, and without even knowing it, we'll have our assets on with our spouse, or as we age, we may add our children to our assets. Why are you doing that? You're doing that, quite frankly, to make sure that if and when you die, that those assets go to your heirs easily because they are already an owner of it. They're a joint owner on that account. This is, again, good if you have fairly simple assets. You have one or two bank accounts, you have one or two heirs. This is an okay way of solving the problem. But if you add any further complications to that situation, you may need to move up the ladder. But before we go there, I do want to mention one other way of owning assets jointly. You can do that what's known as a beneficiary designation on your accounts. If you have a stock account, or if you have a bank account, a checking or a savings account, you can go to your bank and you can add a beneficiary designation on that account. It goes by different names depending upon which institution you're dealing with, but it may be called an in trust for account or go by the letters ITF. It may be a pay on death account, POD account, or it might be a transfer on death account, also known as a TOD account. You'll see that a lot of times with stocks and bonds and brokerage accounts. There's some advantages to doing this. The person that you place on that account with you is not an owner of that account presently, so that any of their problems do not come and become your problems with your money. It insulates your funds and resources from them, but still allows those assets to go to them when you die with very little or no effort. Now, if you have a more complicated estate, you'll need to move up that rung, up that ladder to the next rung. And most of us have heard of a simple will. Simple will, quite frankly, is probably one of the easiest ways of solving this problem. Wills have been around with us since the time of Caesar. There's basically instructions from you as to where your stuff is supposed to go, who's supposed to get it, in what share, and who's in charge of your affairs after you die. All of that is laid out within a will. Now, the legal requirements of setting up a will are very specific and really need the assistance of an attorney in some way to make sure that it gets done correctly. You wouldn't want to have a document that's not done correctly only to find out that your wishes are not being carried out because of some simple technical requirement was not met. I strongly encourage you, if you are going in this route, that you have an attorney help you set that will up. A will is an easy way of doing this, but many people don't like it because it involves the probate process. As you become more complicated in your estate, meaning more complicated assets, you have houses in different states, you have multiple different types of assets, you have multiple beneficiaries. Maybe some of those beneficiaries have unique challenges, whether they're special needs or minors, or whether you want to hold it back and not give them the lump sum. All of these kinds of issues, challenges, are much better dealt with using a planning technique called a trust. That moves you to the next rung on the ladder. Now, these rungs from doing nothing up to a trust will solve the estate planning problem for about 95% of the people in our community. There are some people who need to go beyond that top rung and deal with some other more sophisticated estate planning plans. But in this context, most of us can solve the problem with either a will, a trust, or a joint account. Now, a trust sometimes scares people because they think that they're giving up control of their assets, that the bank is going to be in charge of their affairs, or there's going to be a trustee that they don't have any control of. There's a lot of misinformation on how a trust works. Trust is none of that, actually. A trust is merely setting up an entity that you control, that you're in charge of, that you make the decisions, that you put money in and take money out, that nobody else tells you how to deal with it. It also provides the added benefit of avoiding the probate process. Remember, if you have a will, by definition, it will go through probate. Probate's not necessarily a bad thing, but there are costs associated with it of time and of money with the attorney's fees. The trust allows you to reduce those expenses, those time expenses and those attorney fee expenses dramatically, reducing the size of your bill, so to speak, for dying. Now, a trust, oftentimes I will get asked, well, how much money do you need to have in order to have a trust? There's a number that somebody's trying to grab a hold of. Do I need one or not? So I'm going to give you that number. The number that you should look at when you look at the overall size of your estate, not counting the value of your house, is that if that estate is worth more than $100,000, you should start considering the use of the trust as your solution to planning for your estate. Doesn't mean that it's absolutely necessary or that's the only way to go, but having more than $100,000 starts making a lot more financial sense for you and your family to consider using a trust to move your assets to the heirs that you want them, to the heirs you want to receive them. You know, there's a lot of other issues related to estate planning that you need to be aware of. I encourage you to go out in your research to find out this information at your local library or on the internet. You can find some good information at virtuallawoffice.com, also at floridamedicaid.com, flmedicaid.com. I'm Sean Scott, in your best interest.